Hi again. So today we'll talk about the basic composition of the contract. Like we already reviewed the synopsis, and we'll be talking about agreement, contract, the binding nature of a contract, the classification, and then we'll go fully into the element of a valid contract. So to start, you have to understand what actually makes an agreement a contract. While it's popular to say all agreements are contracts, it's important for you to know that it is not all contracts that are agreement. Sorry, while all contracts are as a result of an agreement, it is not all agreements that are contract. This is very important for you to know. So it's possible for you to have an agreement with your friend, and that agreement is not a contract. But the moment you have a contract with somebody, that contract is definitely an agreement. So, what are we trying to say in this context? Basically, we're trying to say it is not all agreements that are enforceable in a law court. So, for you to know what qualifies as a contract, for you to know that kind of agreement that qualifies as a contract, then you must be able to determine based on the enforceability of that agreement. So if the agreement is such that you can go to court to go and seek a redress or to go and enforce or to go to ensure that the terms comes to pass, then that kind of agreement qualifies as a contract. But the moment that kind of agreement cannot be enforced in a law court legally, then it is just an agreement and not a contract. And that is why we say all contracts are agreements, but not all agreements are a contract. So basically, it's possible for you to have an agreement between two people. It could be between an individual and an individual. It could be between an individual person and a corporate person. That is why you have a firm. It could be a company. It could be a group of persons, an entity. So an agreement does not necessarily have to be between a buyer and a seller. It does not have to be you buying and selling something. It could be a kind of trade by barter, giving something in return for a benefit that you are getting. By the time we start talking about the elements of a valid contract, you understand more about this. But it's enough for you to understand that a contract can be between an individual and an individual, a corporate entity and a corporate entity, an individual and a corporate entity, or a corporate entity and an individual. It could be in that way. And there is no hard and fast rule that says an agreement must be between two people. It could be between more than two people. And the persons that form part of this agreement, whether an individual or a firm or a corporate entity, are called parties to a contract. I'll repeat that. The moment you are part of a contract, you form part of those people that come to make an agreement that you want to enforce in a law court, you are referred to as a party to a contract. So you have to learn all these terms and know how to use them appropriately. So in a typical law setting, as a law student, you are expected to refer to these people as parties to a contract, so not as individual or firm. So another important thing about an agreement that will make it qualify as a contract is that it must be voluntary. Now we're trying to decipher the things that must be present in an agreement for you to cross over from a mere agreement to a contract. So there must be an agreement between two or more parties. Such agreements must be voluntary. You cannot be coerced to enter into an agreement with somebody. That agreement will not qualify as a contract under the law. So to qualify as a contract under the law, all the parties to the agreement must enter into such an agreement voluntarily, without coercion, without force, without intimidation of any kind. And then another thing that makes it important, and that is the most important thing about a contract, is that that contract must be enforceable. It must be legally binding. So the moment you cannot take the contract to court to say this person has not fulfilled his or her own part of the bargain, and I want the court to give me a compensation for the failure of this party to fulfill his or her own end of the agreement, then that agreement is not a contract. So in that context, we will say the agreement is legally binding, or the agreement is legally enforceable. And what makes it enforceable is your right to take it to court to enforce the terms and the conditions of that contract. Another thing is, it is not in all cases that you enter into an agreement that you sit together to say, these are the things we are agreeing. In all cases that you sit together to spell out the terms and the conditions of the agreement, such that you may have you may have done some things in the past, maybe based on the kind of relationship you share with the other party, that makes a reasonable person to deduce that there's actually an intention to create a binding agreement. And that is why we say a contract may be express or it could be implied. When it is express, it means the parties come together to spell out what the agreement is all about. When it is implied, it means, based on maybe past relationship or what you can, the circumstances surrounding that agreement, then a reasonable person can say there is an intention or there is a contract between these persons, between these parties. Now, when you talk about circumstances like that, and then we link it to a reasonable person. And when we talk about reasonable person, in the context of law, a reasonable person means we call it a test. There's a test to determine the reasonableness of a person, and that is called the objective test. So when you want to imply that there's a contract, what you apply is an objective test. And the objective test is also referred to as a reasonable man's test. And how do you determine this test in a typical law scenario? It's by saying, if you put 10 people, average thinking people, in a place and you present them with a scenario, what would 8 or 9 of them make out of that scenario? So, like in a normal situation, what would a normal or a reasonably thinking person think of a scenario that you possess? So that is what we mean by a reasonable man's test. Again, such an agreement could be oral or written. And that is to tell you that it is not in all cases that your contract must be documented, which means even when your contract is parole, that is, it is oral in nature, you just agree verbally. You don't have any written document to show that there's a contract. If you can establish it in court that, we actually agreed on this, and the other person agreed that, yes, we agreed on this, and then the intention is to be binding and all those stuff, then it is still a contract. So, irrespective of the fact that a contract is not documented, it is not written, it is still possible for such an agreement to be a contract. So a contract could be oral, it could be written. So based on this, I would actually implore you to attempt a definition of contract, taking all those elements that we've talked about into consideration. So I'll give you 1 minute to attempt a definition of contract. Make sure you do this. Post it on Canvas. I'll open a conversation on Canvas. So post your definition of contract on Canvas. I'll review it and give you feedback as you make your post. So please make sure you do this before the end of the week, latest by Friday, and then before Sunday, you get your feedback on your definition of contract. So I won't give you my definition. You have to come up with your definition, and then we'll work with your definition. And if there are some gaps in your definition, I'll give you that feedback. So please take out time to do this and post on Canvas. So let's talk about classification of a contract. Like we already said, a contract can be express, simple, implied, or formal. But in order to classify a contract effectively, it's better to approach it from any of these 4 bases. You want to classify a contract looking at the mode of creation of that contract. You also want to classify a contract looking at the way in which that contract would be performed. You want to classify a contract looking at the parties involved in the contract. You want to classify a contract based on enforceability of the contract. So it is possible to actually say you can classify your contract in 4 different ways. At the same time, you may see some text that will tell you they are classifying contract into 8, 9, 10 different methods. Whichever approach you adopt is okay, but you really have to understand the idea behind the classification of contract. So to make it easy for you, I will say classify your contract in these 4 basic modes: mode of creation, mode of performance, the parties involved, and the enforceability of the contract. So if you want to classify your contract based on the mode of creation of the contract, you want to look at it from the view that it is possible to create an express contract. And like I said earlier, an express contract is that contract where the parties come together, spell out the terms and the conditions of the contract, and then agree on what is to be done expressly. So they are all on the same page on what is to be done, what the expectations are, what the remedies are, or the pros and cons of the contract are expressly spelled out. Then you have a mode of creating a contract which could be implied. This is where the parties do not come together to say these are the things that we actually express under this agreement. So, but maybe due to past relationship or maybe circumstances surrounding the contract, then you can imply, and that is where I talked about a reasonable man's test. You can imply that, oh, these are the terms of the contract, these are the expectations of the contract. So in such a case, you say, oh, there's an implied contract in place. Then you have a simple contract. A simple contract, like the word connotes, is a simple contract. It means the contract is maybe oral. So when you have a simple contract, it is oral in nature. It's not documented. And it could be simple in the context that all the terms are actually not written down. Probably you buy something and you get a receipt. That receipt is proof of payment for what you're buying. Whereas it is not fully documented because you have some part that is parole, that is oral, and you have some part that is documented. The receipt shows that you've bought something that is indicated in the receipt, but the negotiation that led to that purchase is not documented. So that kind of contract qualifies as simple, where it is completely oral, or you have part of it oral and part of it written. Then you have what is called a formal contract. So a formal contract is what you refer to as a contract under seal. It is popularly referred to as a contract that is signed, sealed, and delivered. Signed, sealed, and delivered in the context of the parties spelling out all the terms of the contract. And all the parties to the contract appending their signature or their marks on the contract. And then when we talk about delivering the contract, it means each party to the contract gets a copy of that document. It means there is a document to show what the agreement between the parties are. In such a case, you call such a contract a formal contract. During one of our tutorial sessions, I'll show you a sample of a formal contract for you to understand what we're talking about. So another method in which you may classify a contract is by mode of performance. You can also classify your contract by looking at the mode of performance of the contract. So in performing your contract, it could be executed contract or executory contract. When you talk about executed contract, it means all the obligations will be fulfilled, and then the other party will fulfill the obligations, and then that brings the contract to an end without any future obligation on the parties. For instance, if you want to buy a textbook, and then you negotiate for the textbook and you pay, and the seller gives you the textbook and gives you the receipt for payment, that is the end of the contract. There are no future obligations. In such a case, you say the contract is an executed contract in which the terms are spelled out, and once one party fulfills his or her obligation, the other party also fulfills his or her own obligation, and that brings the obligations to an end and the contract to an end. However, in the case of an executory contract, they are saying there are future obligations that are created under the contract, such that even when a party has fulfilled his or her own obligation, the contract is not terminated immediately. There are still some future expectations on the part of one party, such that if that party defaults, you can still go back to enforce that part of the contract. For instance, if you engage an artist to play for you at an event, and then the person is to deliver maybe a recorded copy of the, okay, for instance, if you engage a photographer to cover the pictures of your birthday party, and you've paid the person, the contract is not terminated upon completion of that party. That photographer has to go back, probably to edit the pictures, deliver the photo book to you, and maybe the soft copies of the contract. So even after your event, after your birthday party, there are still some obligations, there are still some duties that the photographer must fulfill to you, which means even after your birthday party, the contract is not terminated at that point. That party must still continue to work on what the terms are in order to fulfill the obligations on his or her own part. And if you also have outstanding payment, then you still have to pay that. So that is an executory contract that has future obligations. A perfect example of that is like, if you look at some toll gates, like Lekki toll gate, it's a kind of contract that was built on a build, operate, and transfer basis, such that the government did not really advance the money for the contract, but entered into an agreement with a company to build the toll gate, collect the fee for some years, maintain the road before transferring to the government. Whereas the government owns it, there's still a future obligation of the road maintenance on the company that won the bid for the toll gate. So that is a kind of contract that is executory in nature. It does not terminate with the completion of the immediate task, but it has a future obligation on one or both parties. Another way to classify your contract is to look at the parties involved. Is it bilateral in nature or unilateral in nature? Like the word connotes, bilateral means between two parties. You could also have multilateral parties, that is between more than two parties. So you want to look at that, okay, is it a bilateral contract or a unilateral contract? So, and for you to determine that, you must know whether it involves two or more parties or only one party. So it is bilateral where both parties are in agreement of what constitutes the terms of the contract. It is unilateral where only one party determines what constitutes the content of the contract. And this will become clearer when we discuss the case of Carlisle and Carbolic Smoke Ball. You will understand what a unilateral contract is. So I don't want to go into details now. Then you want to look at how to enforce a contract. That is another way of classifying a contract. It is possible for you to have a contract that is valid but not enforceable. It is valid, but you cannot enforce it in a court of law, probably because you have not fulfilled the conditions of the law. So you want to look at it, is this contract valid and enforceable? That is one way of classifying a contract. Is this contract void? When it is void, it means you've defaulted in complying with the law, as a result of which that contract from inception, from the point that you entered into it, is not valid and not enforceable at all. Then you want to look at whether the contract is voidable. A contract will be voidable when At the point of entering into the contract, it is valid. But due to a defect, you can make it void or you can make it valid. So the defect is always at the instance of a party, such that that party, there's the law is on the side of that party, and that party now has a choice, either to ratify the contract by making it valid or to set it aside and say, no, I don't want this contract. So these are things you really have to take note of in order to classify your contract and know whether the contract is actually an enforceable contract. I think that this is a good place to stop for today. And then I will still upload another one for you, on another slide for you on, on the basic rudiments before we go into the core elements of contract. So I will expect you to post your definition of contract on Canvas so we can start our discussion this week. So have a good day.